Hey class, today we're going to talk about an overview of the civil trial process. We'll talk a lot more about this in class, but this is the basic structure and organization of how a trial would proceed in the American judicial system. We'll simulate a bunch of this later in the semester as we do our mock trials. We'll start with the trial choice, the question of trial choice. We've talked about juries and bench trials. So the question becomes, who gets to choose whether a case proceeds as a jury or bench trial? And that, in a civil case, falls to the plaintiff. The plaintiff chooses whether or not they want a jury trial or whether they want a bench trial. This decision is based on a number of factors. Frankly, one is cost. Bench trials and also time. Bench trials tend to proceed faster. Jury trials take more time, and time is money. You're paying your lawyers, even if you're paying your lawyer on a contingency fee, which means a percentage of any award that they receive, they're still charging you for expenses, trial preparation, copies, all that kind of thing. A jury in a trial is referred to as a petit jury, little jury in French. These are the ones you see on TV, on Law and Order, and in most cases. Fellow citizens considering the facts of a case and deciding the liability, with the judge acting as a referee. The number of jurors in a case at the state level varies. Each state requires a different number of juries. And it also varies based on the kind of case that you're talking about. Usually it's between 6 and 12. Decisions, how many people have to agree, also varies by state. Decisions are usually required to be unanimous, but that's not a requirement. That's not a constitutional requirement in civil cases. There are some states that don't require unanimity in criminal cases. So it's hard to say how many. Each state has its own number. Jury deliberations, however, are always private. It is not a public process for the jury to come together after a trial is completed to discuss the case and then attempt to arrive at a verdict, at a decision in the case. Now, the bench trials, on the other hand, the judge hears the facts and determines liability. There's no jury, and thus one of the nice things about a bench trial is that the attorneys don't perform. They're not performing for an audience of the jury and doing some of the histrionics that are that can come out. If the glove does not fit, you must acquit. That kind of stuff wouldn't fly in a bench trial where the judge is determining both liability and refereeing the legal matters within the case. But sometimes you're going to get a much higher award if you're a plaintiff from a jury than from a judge. So again, whether you choose a bench or jury trial is kind of up to the individual and their trial strategy. Now, a petit jury, these kind of juries, a regular old jury in a trial, is different than a grand jury. A grand jury, a big jury, grand is French, grande is French for big, essentially, which is part of the criminal process, which we'll talk about in a later lecture. Now, pleadings are a critical part of every trial. Pleadings are the formal written documents filed with the court that advance the case. They initiate the case and then advance the case. They allow for the litigants, for the participants, the parties, to present evidence, to ask the court, require the court to enforce the requests, to answer the charges brought, or the allegations, the accusations brought by the plaintiff against the defendant, etc. Every case, civil case, starts with a complaint. The plaintiff, complainer, the plaintiff files a complaint to initiate the case. The complaint does a number of things. it establishes jurisdiction of the court. It says why this court should be considering this case. It lays out the allegations, the charges, the claims that the plaintiff says, here's why defendant X owes me money, for example. It lays out what the plaintiff wants to recover. Is this a suit in law or a suit in equity, or both? Do they want money? Do they want some sort of other thing that the court can deliver? You know, an order of protection, for example. So the complaint is filed and then served on the defendant, and the defendant has a certain amount of time to answer the complaint. The defendant, in their answer, responds line by line, paragraph by paragraph, to the allegations in the complaint, and often also advances defenses, affirmative defenses, against the claims made by the plaintiff. We'll talk more about this in class. Don't worry. I'll be showing you all my old documents and examples from when I was an attorney and, you know, doing the motion practice. Now, again, a critical piece of the American court system is discovery. In the vast majority of states and at the national level, both sides of a case have to disclose evidence that the other side asks for through the process of discovery. There's no trial by ambush in the civil courts. And so we have a process of full disclosure. I mean, if you file different pleadings with the court, and then the court enforces those requests for production, for example, and the judge acts as the referee for throughout the process of this pre-trial discovery process. So you might submit interrogatories, which is just a fancy way of saying questions. You submit questions to the defendant, and their answers are sworn legal documents, so you can ask for their answers, and they answer the interrogatories through another pleading. You might depose, a deposition, depose any number of witnesses. It's a formal examination of a witness, and you can ask them just about anything, and both attorneys are there, and this is testimony before the court that will be submitted at trial. You can ask them to produce tangible evidence or through a request for production. There's lots and lots of different ways of discovering information. And the whole point of this discovery process is that in the adversarial legal system that we have in America, if both sides are producing the information that the other side asked for, A, there shouldn't be surprises at trial. B, it incentivizes both sides to take a hard look at their case, warts and all, and decide whether or not to proceed with the trial or settle the case. For both sides, they also might then proceed to additional motions to dismiss, for example. These are motions with the court where the sides are making a formal request by one or the other party to the court asking them to do something. So, a motion to dismiss. Hey, court, the other side didn't respond in a timely manner. They continue to stonewall. We think this case should be dismissed because they don't really have a legal claim to stand on. Or once discovery is completed, you might file a motion for summary judgment. Hey, the other side's presented their half of the case. They haven't proved the basic elements of whatever legal claim they're filing, or that they filed. Thus, this case can't succeed on the merits based on what the plaintiff has laid out. There's lots of different motions. You can have a motion to change venue. You can have there's just lots of motions, suffice to say. They're a really important part of the pre-trial action, and of course the trial action, because you're trying to bring a case to either settlement, resolution, or trial. And if the plaintiffs don't have a case, don't waste the court's time, right? Don't waste everybody's time and money. And if the plaintiffs show that they have a really strong case, the defense is incentivized to settle the case, possibly for less money than they would face in a jury trial, for example. So this is a balancing act that both sides are doing throughout this process. Now, again, this is a generic, very rough overview of the steps of a civil trial. Once you get through the motion practice and the pretrial motions and all this, if it's a jury trial, you got to pick your jury through the process called voir dire. And again, we're not going to go much into the jury process, the jury selection process, excuse me, except to say that both sides get to ask potential jurors questions about how they feel about a particular matter. So if you're in a case involving a car accident, both attorneys on each side might ask potential jurors of a jury pool, have you ever been in a car accident before? Have you ever caused a car accident? Have you ever been on the victim of a car accident? These kind of questions. And then you can pick and choose who you want on the jury. Both sides can pick and choose who they want on the jury. Once you got your jury picked, both attorneys will present an opening statement where they lay out in succession their view of this case. And they're telling a story. Okay, the trial is effectively a storytelling exercise. You're trying to help the jury see what happened from your perspective and thus explain why your side, your client, should prevail. Okay, and how do you do this? Well, first you start with the opening statement. You kind of give the broad brushstrokes about what the case is all about and why your client should prevail. And then you proceed with a direct examination of the plaintiff's witnesses. The plaintiff calls witnesses to talk about what they saw. Now, remember, we also took depositions of those same witnesses, so if they deviate from what they previously said, the cross-examination by the defense can trip up the witness and cause them to lose some credibility with the jury and the court. Again, after direct examination of the plaintiff's witnesses and a cross-examination of the plaintiff's witnesses by defense, there might be some motions filed, motion for summary judgment, that kind of thing. Then you can proceed with the presentation, the case in chief of the defense. The defense presents their witnesses, generally either repudiating or otherwise explaining what really happened. Plaintiffs get to cross-examine the defense witnesses, just like the plaintiff's witnesses got cross-examined earlier. You might have some motions fly back and forth, and then you have closing arguments. This is where the attorneys tie all the witness presentations together, the presentation of evidence, and tie it into a coherent story that ties into their opening statement, ideally, where they're showing how they proved either liability for the plaintiff or showing how the case doesn't hold water on the defense side. And there's jury instructions. The judge tells the jury about the law, and then the jury deliberates. That's generally, in broad brushstrokes, the steps of a civil trial. We are going to do that process in class through a simulation. A little later in the semester, you will be playing the litigants, the juries, the witnesses, all of that stuff. It's a lot of fun. Anyway, I will see you in class tomorrow. Take care.